The context of the New York Times versus Gonzalez back in 2006 is around the media's pursuit of information about post 9/11 surveillance activities and the government's response in withholding access to such documents. Following the terrorist attacks of September 11, 2001, the United States government put in place a number of measures to strengthen national security and prevent future acts of terrorism. One such step was the expansion of surveillance programs aimed at gathering intelligence and monitoring potential threats. This investigation began in October 2001 when the New York Times published an article indicating that the GRF was being examined for inclusion on a list of organizations with potential ties to terrorism. The reporters, Judith Miller and Philip Shannon, approached the foundations for comments on the government's efforts to seize and freeze their assets and finance. According to the authorities, these communications informed the organizations, resulting in steps that hampered the efficiency of following searches. After this, the government asked the reporters for voluntary interviews and phone records, but the Times refused, citing First Amendment protection for confidential sources. The government asked again, warning that it would demand phone information for third-party service providers. The Times persisted, claiming that such requests would provide the government access to all sources over the stated time periods. After exhausting all other efforts, the authorities obtained the phone information from third parties without informing the Times. The publication contacted service providers, demanding notification if they received government demands. The suppliers refused to cooperate. The government argued that it had followed proper procedures and did not need to give the Times the option to protest the acquisition of material from third parties. Following this, the Times responded by filing a lawsuit seeking a declaratory declaration that the reporter's protection against compelled revelation of secret sources. The court then issued a summary judgment in favor of the Times, citing qualified privilege under federal common law and the First Amendment. After what, of course, Gonzalez filed an appeal against the court's verdict. In this situation, the Declaratory Judgment Act lets a district court say what the rights and legal ties of the people involved are. In cases that are already in court, the court can choose whether or not to make a formal ruling. Gonzalez said that the act didn't apply in this case because the New York Times claim could be looked into through a special statutory proceeding in Federal Rule of Criminal Procedure 17C. After looking at the legal decision, the court ruled that Rule 17C was not a special legal procedure that stopped a declaratory judgment case. Regarding the First Amendment, this is meant to protect the freedom of press, and the case was about reporters' privilege, which kept journalists from having to reveal their private sources. The New York Times said that the subpoena for the phone records couldn't be carried out because the writer had a right not to have to reveal confidential sources. The court agreed with the New York Times and said that the reporter's privilege was in effect. The case of Brandsburg versus Hayes, decided in 1972, is the main case of precedent with regard to the matter of the New York Times reporters. Several reporters argued that they should not be compelled to testify before a grand jury over material they obtained under secrecy. The court decided by a vote of 5 to 4 that reporters did not have a right to refuse to testify. The Judge Justice White wrote the opinion for the majority, which was against a privilege for journalists to give testimony. The opinion said that the subpoena given to a reporter in bad faith could be against the First Amendment. The Judge Powell also agreed with the majority, but he made a separate comment about how limited the majority was. He said that a reporter can try to get a subpoena cancelled if they think the grand jury investigation is not being done in good faith, or if the information being asked for has only a small connection to the investigation. And lastly, the Judge Justice Stewart disagreed with the majority, but he did support a limited First Amendment right to reporters to keep their sources secret. Brennan and Marshall, both justices, agreed. But Justice Douglas' dissenting opinion said that the journalists had the right to not talk to grand juries about their work unless they were accused of a crime. So, the conclusion of the case of the New York Times versus Gonzalez ended with the Federal District Court denying the defendant's move to dismiss and giving the New York Times a declaratory judgment in its favor. The court decided that the Declaratory Ruling Act let the New York Times get a declaratory ruling to protect its rights. It decided that the reporter's privilege against being forced to reveal private sources applied in this case, protecting the journalists from having to say who their sources were. The court basically agreed that the freedom of press and the reporter's right are important parts of the democratic society. It supported the right of journalists to keep their sources' identities secret, even when the government was looking into them. By giving a declaratory ruling in favor of the New York Times, the court said that the government could not try to get the journalist phone records in this case. Overall, this case showed how important it is that the First Amendment protects freedom of the press, and that the writer has a special right. The decision set a big example on the rights of journalists and how far the government can go when it comes to getting information and covering news. My questions to you guys are: how did the court's decision in this case affect the way media kept their sources secret? And what was the court reasoning behind recognizing the reporter's privilege and granting protection to journalists in this context?